Now back to the show. This is The Law Show on CL 650.
And welcome back. And we're talking about trust to start with here, estate law and estate planning with John Lakes and John White from LakesWhyteLLP in North Vancouver. And we talked about underage children. I think this is probably one that most people are interested in because you have children that can't make decisions. They're not, mature enough. You have to have a guardian and you have to have a trust to look after their needs and pay for all the stuff that kids are expensive. It's hockey, it's soccer, it's school, it's university, it's all of that kind of stuff. So what do you do in a situation where you say, okay, we have this trust and the money is going to go to a child when they hit 25, but they're really irresponsible. They're maybe substance abusers and they're not hanging out with the right people and they shouldn't inherit this $500,000 because who knows what they're going to do with it. So is there an opportunity inside that trust to extend the time to which they're going to get their funds?
Not necessarily unless the will says so. If somebody's mentally incompetent, you can have it extended. So I've had clients who keep changing the age of majority, age of the trust runs up, up to 40 and then they give up. So you can create trust for adult children that are competent. You may have reasons such as, let's say your daughter's going through the marriage from hell and you want to protect the estate assets from being a family asset. You might have a child who's got problems with debt. You have problems with children who've got mental health issues, although they're competent. I think the problem is you've got to be realistic when you do the will, because the problem you have sometimes is that if you're not realistic and sure, your daughter's going to get $500,000, but it could be gone in 2 years.
Mm-hmm. That's what I'm saying. They're irresponsible. They're hanging out with the wrong people. Maybe they drink too much, or who knows what it is.
Well, you've got to foresee this in advance.
But you might not know maybe you pass away and they're 14, right?
Right. Well, in that scenario where if you've passed away while they're 14 and they're not exhibiting any problems, and they're to take $500,000 when they reach the age of 25 and they sort of fall off the wagon in the intervening years, there's not an awful lot the trustee can do about that.
Mm-hmm. So there's not a way to extend the delay of the funds.
Well, no. The job of setting up the terms of the trust belongs to the will maker.
Can you write that in the will when you're writing a will to say the trustee has the ability to extend this to the age of 30?
I wouldn't do that because it'd be challenged. Because sometimes, I'm used to when someone dies, all of a sudden people want the money 6 weeks ago.
Yeah.
And sometimes the people that are most desperate are the people that are a bit deceptive. They're the ones who may have the nice car and the nice apartment, and
they're leveraged up.
They're leveraged to count on that $500,000 inheritance to get them out of the jam. So the person doing the will has to be realistic, and there's, if the person's over the age of 19 and competent, you're only limited as to what you can do. And even if you create an ironclad trust, again, the child could go to court to try to challenge the trust too.
So that's the money part of it. There's also the guardian part of it, which means the person that is ultimately responsible for the decisions for the child, right?
So in a will, you should name, if you've got children under the age of 19, you should name a guardian. And my recommendation is if it's somebody who's married, you should name your sister and brother-in-law, because let's say if your sister's away and your son falls out of the tree, you want to make sure that the brother-in-law can go to the hospital and get a cast put on. So, but ask people ahead of time. Don't surprise them. Mm-hmm. And you may also have to work out accommodations. So for example, as I said before, if you appoint your sister in a one-bedroom apartment, you may want to keep the house. If you've got 4 kids and your brother has got only 2 bedrooms, you may want to provide that the estate can give him a mortgage to provide accommodation for your children, but the mortgage is paid when the house is sold and the kids reach a certain age.
So this surprise factor that the people have not been notified that they've been listed as a guardian or a trustee, what percentage of that in your experience happens?
Well, fortunately for myself, I've had very few cases of both husbands and wives dying, and every case I have, the person knows.
Right.
Yeah, we have seen cases where executors, or an executor of an estate has
no idea they're named, right?
No idea until they're told that they suddenly become the executor. And, you know, we've had a case recently where somebody in that situation just said, you know what, I didn't sign on for this. Nobody told me about this. I'm not going to do this. And they renounced, as they're entitled to do.
So anybody who's been listed as
Yeah.
an executor can say, no, it's not.
Yeah,
This is not the job for me.
You're not forced into this. It's not a prison sentence. If you really don't want to do it or don't believe you can do it, you have the ability to renounce. If you don't think you have the ability to do the job, you probably should renounce.
Okay, so what do you do in that situation? Do you go to court?
Well, we're back to court. I mean, courts, as I've said in an earlier show, take issues. I mean, they take all issues seriously, but they really take wills issues seriously because the person whose property they're dealing with is no longer around to speak for themselves. And in a scenario where the one executor named in the will has renounced, and so there's nobody left, one makes an application to court for something called an administrator, either with will annexed if there is a will, or without will annexed if there isn't a will. Those can be contested. You know, we saw a battle between a brother and a sister, where the sister wasn't even named in the will, except to be disinherited. But had a claim under the wills variation proceedings of the Wills, Estates and Succession Act. And the court looked at that and thought, you know what, to name the brother as executor in this circumstance or administrator in this circumstance when the number one thing he's going to do is fight off a claim from his own sister, that's just going to lead to a war. And so we're going to appoint somebody more neutral.
Okay. Now, you were telling me in a previous show that the judges in the court actually they like getting a change of pace when it comes to estate law, because these people are in court every day hearing, you know, different kinds of trials. Maybe there's the civil disputes, what have you. So this is a bit of a mystery for them, right? Don't they look at it as a bit of a, you know, whodunit? But because you always state the person who has passed away can't come forward and state what they wanted to do.
Well, they can be interesting. I would not suggest that every judge necessarily is particularly intrigued or looking forward to dealing with some kinds of estate cases, because some kinds of estate cases, like the one I just described, they're just family wars.
There's no winner there, right?
There's no winner. They've got to be difficult to listen to, and they require a good deal of good judgment to decide. But there are cases where they're more academic. They're a lot more, dare I say, gentlemanly in the way that they're conducted, and it's an interesting exercise for lawyers and I think for judges while they try and divine what the intentions were of the now deceased will maker. That we get that when we are trying to construe or have the court construe an obscure or uncertain provision in a will. And yeah, they can find that quite interesting, especially where there are two different points of view that are both legitimate.
Okay, interesting. Now, we touched on children underage. I think that's important for a lot of people. Adult children that you mentioned maybe have disability. Now, trust for spouse. Now, wouldn't you just think that in the will that it would state that your spouse is going to get most of your inheritance anyway?
If that's the first marriage, but a lot of times you've got second marriages. So let's say we've got an example where a widow and widower marry each other in their 70s. So they both are coming into the relationship with assets. And hopefully they've also done an agreement as well about their assets. So for example, let's say the husband may want to do in a will where he creates a trust for his new wife, with the idea that she gets to use the house, she gets to use the cottage, she has access, she gets a monthly allowance, but then upon her death, he wants all the assets to go to his children for the first marriage.
Right.
And she may want the same too. And I mean, that is fairly common. There's usually an agreement in place as well, and the agreement has to have independent legal advice as well too. So you see that quite often.
And can anybody contest that and say, well, no, we want the house sold now and we want the money now?
Well, the problem may occur is if, let's say, they've been together for 30 years.
Right.
And they've never updated anything.
Right.
And in the meantime, when the woman moved into the house, it was a 2-bedroom shack, and now it's a 6-bedroom mansion with a world-winning garden, and she's put a lot of money and effort in it. She might actually have an interest in the property by basically a constructive trust argument. So the problem is the agreement could be totally out of date.
Yeah.
And so that's typical of second marriages, trusts for spouses,
Yeah.
right? Are there any other instances?
Well, let's say if you've had your wife's had a stroke, and she's in a care home. So again, what you may want to do if your assets in your name alone, you may want to create a trust for your wife because she's no longer capable of handling her assets. So then you put your daughter in charge or something like that. So that happens as well too. But it's the second marriages that's the most common.
Okay, now let's get into a little bit of the powers that you have to execute these things. Like so what powers are distributed to the person? There's the person as the executor, and then it can be a trustee. And how are they different?
Well, the thing is, the executor's job is basically gather up the assets, pay the bills, and distribute it according to the will, which usually takes 2 or 3 years. Now, an trustee's powers may be to retain the house as opposed to sell the house, to invest the money over a 5-year period as opposed to pay off everything immediately. So it's the executor's job is usually finished in 2 or 3 years, while a trustee's job may be going on for 10 or 15 or 20 years. So generally, when you're an executor, you might pay out the beneficiaries in 3 separate checks, but you don't give them a monthly allowance. So it's a matter of time, really.
Is that more the money side of things?
Yes, and the managing of the assets as well too. So if you're acting for a trust, you may want to tie money up for 3 years. But if you're acting for a beneficiary, they'll want their money once the clearance certificate's issued. So.
Okay. We're going to take a quick break, and when we come back, we're going to get into the signing of a will and how it's so important that it's done properly. On the Law Show, we're talking about estates and wills, estate law, estate planning with John Lakes and John White from LakesWhyteLLP in North Vancouver on the Law Show, next on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.